Mail to your lordship. With regard to item number 8, your lordship, and it will be listed after a month. The amicus curiae is not well, your lordship. It has been operated, is recovering.
Okay. On request made on behalf of Mr. J. Das, then the amicus curiae. List the matter after 4 weeks.
Much obliged, your lordship.
May I please, your lordship? Lordship, item number 14 of supplementary list. Can the matter be taken at 2 p.m. today?
Why 2?
Lordship, we have already taken the consent with the other party.
We'll see. We'll see. Depending on the vote.
Okay. Much obliged, lordship.
Hey, please, your lordship.
Oh.
Lordship, I'm praying for listing of a IA on Friday, my lord. IA is for suspension of the sentence and for bail, my lord. Obligement.
Friday is a holiday, I think.
Okay.
Friday is
There. Then, my lord, on 4th. May I pray for 4th, my lord.
Make it Monday. 8.
Let's obligement.
May I please, your lordship? Lordship, I would like to mention item number 12 with the consent of the other side, as my senior BM Chaudhary is not keeping well. Lordship, can the matter be listed after 4 weeks?
Okay. On request made on behalf of PM Chaudhary and the counsel for the appellant. List the matter after 4 weeks.
Obliged, lordship.
May I please, your lordship? My lord, item number 2, my lord. 1 and 2 are connected matter, my lord, out of same judgment, my lord. This matter may be taken adjourned for this week, my lord, because of
This
illness
is a
of
debt
the
reference case. Amicus is also there, Mr. TJ Mohanto.
Where's DJ Manda?
Nikhil Junior is there.
Is it okay?
Yes, sir.
This is not a case for debt, actually. I've gone through the evidence. Not a case for debt.
On request made by Mr. H.R.A. Chowdhury. Then a counsel for the appellant in criminal appeal 389 of 2018. List the matter after 2 weeks.
Public.
Item 3 to 7 herein.
My lord, my senior is my lord coming, my lord.
Who's your senior?
My lord, NNB Chaudhary, my lord. In item number 5, my lord.
Where's Sarania?
Saranya. He's in another court and just coming, my lord. He's moving a bail application, my lord.
And standing counsel NIA?
It is NIA, my lord.
You are there. We take up after some time.
Nine.
Mr. BC Das is not here. It's a very small matter, otherwise. Is again not here.
Okay, none appears for the appellant. MS John and the additional PP
He might come also.
appears for the state of Assam. List the matter after 2 weeks. We'll see.
He might come also during the course of the day.
Then.
It's Meghalaya. M. Burman is otherwise regular. Today, I don't know. She might also again turn up.
But we can't keep on waiting, isn't it?
Oh, yes, it's. Can pass it over or whatever.
Okay. Then the amicus curiae is absent. MSS Jahan additional PP appears for state of Assam. List after 2 weeks.
Eleven.
My lord, here, my lord, I am led by my lord,
counsel, Mr. P. Kotuki, my lord. He is not yet available, my lord, in the court. And in fact, my lord, other side is also not present, my lord.
Who's the other side?
Other side, they are respondents, my lord.
Other side, Jahan is there.
Yeah,
It's an
it is
appeal
there,
against
my lord.
acquittal.
But it's a appeal,
Okay.
yes.
Other side was Mr. Borgora. In fact, he was waiting on the last occasion during the last week. He was waiting for this matter today.
Today, nobody is there, man.
Ah. Your good name, please?
I am JC Bora, my lord.
But JC Bora is counsel for the appellants. Also heard MSS Jahan Leonard, additional PP Assam. None appears for the private respondents, isn't it? Private respondents. List after 2 weeks.
Deeply obliged.
And we took it. 13.
Court 13 of My lord, my senior will appear for this matter. He is in court 13.
Who?
Court 13. He.
Mr. A. Ahmed.
Yeah.
Lordship, Mr. LNB Chaudhary is here, so Lordship can hear, and after that.
In this case, Kamal Agarwala was appointed as an amicus curiae in this case,
Which case?
in this death reference cases, my lord.
Oh,
So, my lord, প্রথম তো death reference to whom বলবো? First, your lordship will have the death reference. Thereafter, your lordship will go to the case, our case.
Now, there's still a confusion who actually starts in a debt reference cases. Earlier, government used to start because debt reference case is listed
Yes,
as the
madam.
first item. But after, like, the senior advocates are appointed for the accused by the Honorable High Supreme Court's order, the senior advocate starts. That again,
so that confusion is there.
they're confused who
Yes, ma'am.
actually will start.
Yes, ma'am.
Appellant can also start if your lordship allows the, this allows the appeal, then death goes and everything goes.
Everything goes.
Yes. So lordship, even I'm not sure who should start first.
The usual practice is that, my lord, earlier death reference was started by the, my lord, prosecutor, my lord.
This is.
Then
what-
thereafter, my lord, as per order of the, she correctly said, order of the apex court, my lord, amicus curiae has been appointed. In this case, in our case, K. Agarwala was appointed as an amicus curiae. Kamal Agarwala. That is the case.
As in nine.
মই লগ পোৱা নাই নহয়, এতিয়া মানুহে লগ পাইছিল নেকি?
Although the list is exhausted.
List is going on. 10 minutes.
Oh, Mr. BC Das is here. Lordship has otherwise passed it over.
Okay.
Item number 9.
Item 9, we have passed orders.
Very good.
I was sitting in my first item, I saw that is I thought, yeah, there are 8, the number of cases for hearing, I should take about minimum half an hour. So I didn't come early, madam. I may be excused.
Just
Member Colonel is a position.
PC does
No, no, no.
declare.
Wait a minute. লিখিছে আগতে শুনিছিলে
Finishes.
শুনিছে
So what, NNB Chowdhury, what do we do now?
160 on আপনি হেৰি দিব কথা আছে।
Adjourn the matter for a week, my lord. I shall discuss with Mr. Agarwala.
নেকি?
Only for one.
On his behalf, will
Yes, my lord. On my behalf also, my lord, you also can adjourn the matter. I shall discuss with Mr. Agarwala, my lord.
on request made by Mr. NNC Chowdhury. Leonard Counsel for the appellant in criminal appeal 358 of 2018.
Yes, my lord. All are connected, my lord.
On request made by Mr. NNB Chowdhury, Leonard Counsel appellant for the report number 2.
কমল দা তুমি পাইছা নেকি নাই?
Yes, the matter after 2 weeks.
Yes, my lord. কমল দা কোৱা নাই তুমি? কমল দা কোৱা নাই?
Not till now. I have his phone number.
এইটো কিছু কিয় তুমি নাই কিন্তু মিয়া আছে মাছ কমপ্লেক্স মান
Thirteen.
My senior will appear for this matter. He's in court 13. Court 13.
Who's your senior?
Hey, Ahmed.
This is the last matter.
Another matter.
14 is adjourned to 2 p.m. Just quit. We list it after 1 week. On request made on behalf of Mr. A. Ahmed, let it await the list in that after 2 weeks. Yes, item 14.
Wait, this is your lordship. Lordship, my senior, he's on his way. Can the matter be passed over for timing? He's actually stuck in traffic, lordship.
দেখতে পাচ্ছ তুমি নাই তো ইয়া আছে কোন নাম তো বলছি বক্তব্য নেই
Chaudhary,
My lord will kindly come to page number 13, 13. That is PW1. And thereafter, I will again come to this. 13. This is the brother of the deceased, my lord.
informant.
Yes, informant, 13.
Yes.
My lord is there. On 21, 2016, I have got information that my brother, namely such and such, has not returned back from his duty after attending his duty. At around 9 a.m., I was called by my sister. Now, my lord, it says 21, 2016. My lord will kindly take the note, take note of the date, my lord, 21. In FIR, it is 21. Now, here he says it is 20. Yes, at around 9 p.m., I was called by my sister, namely such and such, from her mobile, and I have talked with sister-in-law, that is wife of late Mosang. On 21/1/2016, I, along with some of my relatives from Manao, proceeded to Miao at the residence of my deceased brother. On my arrival, I have seen my sister-in-law was talking to someone over phone. I inquired her regarding any information of my brother. She replied that she has not got any information. I inquired as to whether FIR is filed. She replied that she informed the matter to police. I was surprised to observe that my sister-in-law was not having any trauma, even though her husband did not return back. I have entered into the residence and seen that lots of our relatives were inside the residence and praying. Thereafter, I have proceeded to the PS Miao. I have met EAC Miao at the PS. I was informed that even after their best effort, no information could be found regarding my brother. After about few minutes, one information is received at PS that the vehicle of my brother is standing nearby the TR camp area. TR is Tibetan refugee camp. And one dead body is inside the vehicle. On receiving the information, the police team and EAC rushed to the spot. We have also followed the team. On receipt of the spot, I have seen the vehicle belonging to my brother, and my brother is inside the vehicle on the driving seat. My lord will kindly mark this, where the body was found. It is in the driving seat as per PW1, because it has a bearing on this case. Police has opened the door of the vehicle in my presence. I have seen the dead body of my brother on the driving seat. Again, he reiterates on the driving seat. There was mark on the neck, which shows that his neck was tied by the seat belt of the vehicle. I have also seen blood stain on the abdomen area of the body. On observation, I have seen mark of passing human towards the jungle nearby the vehicle.
Police has observed the procedure and taken the dead body of my brother to the hospital for PME. As it was evening and team of doctor was not there, the PME could not be done on the same day. On 22/12/2016, PME was done at about 1 p.m. The dead body of my brother was handed over to me. I have taken the body to my village and observed final rites. After observation of my last rite of my brother, on 23/12/2016, I went to Miao police station. So on 23/12/2016, he went to Miao police station. I was asked by the police to bring my sister-in-law to the police station for interrogation. Accordingly, I called my sister-in-law to Miao PS on 24th December. On 23rd, he went to the police station and the police told him that call your sister-in-law. He informed his sister-in-law that he should come to the police station on 24th. On PS, I have come to know that police has arrested accused Suman Biswas, who was a driver and used to have a good relationship with my deceased brother and family. It came to my knowledge that my sister-in-law had relationship with Suman Biswas. So in the PS, he has come to know that the deceased was already arrested on 23/12/2016. However, my lord, if your lordship sees the arrest memo in this case, he was shown to have been arrested on 24th of December, my lord. Now, this part, the last para of the deposition of PW1, it is hearsay. Why it is hearsay? Because the police informed him. I was informed by police that when my brother was driving his car on the way, accused Suman Biswas has stopped his car and requested for leave to TR camp area for meeting someone. While returning from TR camp area, my brother has inquired Suman Biswas as to why he is having affair with my sister-in-law. There was argument between both and the accused has killed my brother. I have also come to know that my brother was killed by accused with a knife. Come to know, that is hearsay. The accused person has disclosed that he has thrown out the knife and the mobile of my brother towards the jungle on the PO. As per disclosure of the accused Suman Biswas, police has recovered the blood stain of the knife and mobile of my brother from the jungle of the PO. My lord, I take a small pause here, my lord. My lord, from this para, it is what he has stated is being narrated to him by the police. The police informed him. It is not a case where the recovery was done in his presence, because he doesn't say that in my presence the recovery was done. Neither he say of signing of any seizure memo. Otherwise, he would have deposed that I have signed the signature and he would have identified the signature in the seizure memo. So therefore, this part of the evidence is a hearsay evidence. Why I am making this submission, my lord? During the course of my argument, my lord, I'll indicate the evidence which are held against me. So this point I want to make clear while reading this particular paragraph. This particular paragraph is being narrated to him by the police. The second para, that on my inquiry, this is narrated to him by the housemate of his brother. On my inquiry to the housemate of my brother, namely Sumi Morang, not examined in this case, who stayed with us for about 3 months after the death of my brother, has told me that whenever my brother goes out for attending duty, accused Suman Biswas used to come, and both my sister-in-law and Suman Biswas used to lock themselves inside the bed, and housemate and the child used to stay outside. I have also come to know from my sister-in-law that the accused person, namely Suman Biswas, has extramarital affair with my sister-in-law. Many occasions, both my sister-in-law and accused person used to go out together from the residence of my brother. I came to know that the extramarital affair between my sister-in-law and the accused came to the knowledge of my brother, for which the accused person has killed my brother. My sister-in-law was also arrested in connection with the present case, as she was also involved for the death of my mother. My lord, though she was arrested, but she was not charge sheeted. The accused person standing on the dock is identified by the witness. Exhibit 1 is the FIR. He exhibits the FIR. Exhibit 2 is the memo taking over the dead body, and 2A is my exhibit 3 is the seizure memo, is my signature. Now, my lord, this exhibit 3 does not relate to the seizure of those dao, my lord. Seizure of those dao and the incriminating material, those are different exhibits. Exhibit 3, my lord, in fact, that is there in the record. I have not seen. Cross. Before the incident, I did not know the accused person, and I came to know him after the arrest. I have not seen the accused person killing my brother. Before the incident, I have not seen the accused person with my brother. So in cross, he has denied that he has not seen the accused killing the brother. And that's, in fact, that's the admitted case all through of the prosecution. Now, PW2 is the sister of the deceased. The accused person standing on the dock is Suman Biswas. He is a driver. After my elder brother, late such and such, purchased a car, the accused person taught driving to my deceased brother and sister-in-law. During the year 2016, I was a student of class 12 and I have seen the accused person coming to the residence of my deceased brother. But during that time, I was not aware of there was no relation between the accused person and my sister-in-law. Probably some typographical error. On the previous night of my class 12 examination, when I was sleeping, the neighbor knocked the window. I opened the same and our neighbor told that there was some person in our residence. On that day, my deceased brother was not there and I was shocked as to who else is present at our residence. I went outside and seen that sleeper of the accused person at our doorstep. Thereafter, I have knocked the bedroom of my sister-in-law, but initially she did not reply. On my repeated knocking, she asked as to why I am knocking the door. I asked her as to who is there inside the bedroom. She told that no one is there. I told her that there might be someone inside her room as I have seen the sleeper of the accused person at the doorstep. I told her to open the door if there is no one in the room, but she did not open. Accordingly, I came to know that the accused person was inside the bedroom. On my sister-in-law, inside the bedroom of my sister-in-law during the night when my deceased brother was not there. After about 2 days, my deceased brother came back to the residence and inquired about the matter. I have disclosed him everything that I had seen. After my exam was over, I left for college. On 21/2016, I came back to the residence of my brother, but he was not there. I inquired my sister-in-law regarding whereabout of my brother. She told me that my brother went to the school and within 12 noon, he will come back. On that day, my sister-in-law went away somewhere without disclosing me as to where she is going. She was missing from 2 to 4 p.m. She came back and asked me as to whether my brother returned home. After about half an hour, she again towards Bazaar in search of my brother. The whereabout of my brother was not found, and on the next day, the dead body of my brother was recovered. Cross. I know the accused Suman Biswas standing on the dock since the day when my deceased brother purchased a car. I do not know whether there was any quarrel or threatening between the deceased brother and the accused person. I have not seen the accused killing my brother. So the PW2 probably, my lord, there is nothing in the evidence of PW2 that may connect the killing with that of the deceased. PW3 is a neighbor, my lord. I can skip, but still I'll read. The accused person standing on the dock is Suman Biswas. He is a driver. I used to work in the electricity department. Deceased Morang and his wife earlier worked as Changlang. On being transferred, they came to Miao and started to reside the immediately next quarter of my residence. Since we were nearest neighbor, we used to visit each other's house. Late Morang purchased a car. Since he did not know to drive, the accused Suman Biswas used to come to the residence for driving and teaching them how to drive. I have seen accused Suman Biswas coming to the residence of Mozang every now and then during morning and the evening. After a few days, Mozang has shifted the residence to another colony. After about 11 months of the shifting of the resident, I come to know that Mozang was murdered. Well, that does not help in any way. I'll skip the cross part as well, my lord. Earlier, I did not know the accused person, but since this, the page number 20, PW 4, that is also, my lord, a neighbor, nothing much, my lord. My resident and the resident of the deceased are at the same colony. The wife of the deceased used to work with me at the same office. We used to come and go to the office together. I do not know how deceased died. Before about 6 months of the incident, they have shifted their residence to another place from our colony. And during the time of the date, we did not have close acquaintance. The accused standing on the dock is Suman, who is known to me. He used to come to our colony. My lord, nothing much, my lord. Then, my lord, yes, page 22, that is PW5. PW5 is the wife of the deceased. She was one of the accused person who has been subsequently made as a witness. And she was not charge sheeted, my lord. The accused person standing on the dock is Suman Biswas. He used to work as a driver. After my husband purchased one car, he taught my husband to drive. He has also taught me how to drive. The accused person used to come to our residence as we had good relationship with him. Whenever we used to go for any outing, we used to take the accused person as our driver. On the day of the incident, the accused Suman Biswas called me over phone and inquired as to where is my husband. I disclosed him that my husband went to office. As my husband went away to office, I also proceeded to my office. When I was at my office, my brother-in-law, who used to reside at village, called me and asked to receive him from Naughat port. As while coming to Miao, they had to cross one river. During that time, I called the accused as to whether he can go to Naughat for receiving my brother-in-law. But thereafter, the accused person has not affirmed as to whether he can go to receive my brother-in-law. During lunchtime, when I went to my residence, I have met my brother-in-law who came to our residence themselves after crossing the Naughat. As I had some work at sawmill, I went to sawmill and stayed there for some time. While coming back, I entered the market for recharge of my mobile as I was not having balance. Thereafter, I went to the office. When I returned back to my residence, my brother-in-law went away from our residence and my sister-in-law came to my residence. During that time, my husband did not return from school. As such, I called on his mobile, but his mobile was switched off. Thereafter, I went for practicing for carol dance and it was Christmas time. When I was at practice, I again called my husband, but his mobile was switched off. I called Gaubura of Nampai village as I had to pay him money for the bamboo purchased from him, but his mobile was also switched off. I thought that it was network problem. After practice, I came back to my residence, but my husband did not return till that time. I inquired sister-in-law as to whether my husband returned. She replied in negative. During that time, I had again called Suman Biswas to inquire whether he has seen my husband or our car. He replied that he has not seen my husband. Since it was dark and my husband did not return back home, I went towards market in search of in search of him. During that time, one of my colleagues who went with me in search of my husband, but we could not find him in market. Then we went to the residence of one DL Mitro, who is a colleague of my husband, to inquire as to whether he knows whereabouts of my husband. He told me that my husband did not went to school that day. During that time, I was in tension. I called the Gaubura of Nampai village. He told me my husband did not come there. I called another colleague of my husband. He also disclosed that my husband is not at his residence. I have tried my level best to search for my husband and called almost all known persons and public leaders asking whether whereabouts of my husband, but I have not received any information about my husband. I have not received any information regarding my husband. I went to meet the circle officer, madam, and informed everything to her. She asked me to file FIR at PS. Accordingly, I went to PS and informed the matter to the police. Police, after receiving the information, has told that they will find my husband and they have asked me to come to PS on the next day. During the night itself, I have called brother of my husband and informed that my husband, who went for school in the morning, has not returned and his number was switched off. Now here there is a contradiction between the two PWs. The brother said he called him, sister-in-law says he called, but though I'm not relying much on this. On that night, I could not search for my husband. On the next day morning, I again called accused Suman Biswas asking for his vehicle for searching my husband. He told me that his vehicle is damaged and he is going to Jagon for repairing the same. I went to PS when I had seen the accused person crossing the PS on his car. After few minutes, police chased out our car. During that time, there was one public leader. All of us went with the police on the vehicle of that person towards the place where our vehicle was crashed out nearby the road. On searching the PO, I have seen that our vehicle was nearby the road and the dead body of my husband was at the front seat nearby the driving seat. Since the key of the vehicle was not there, we had bought the additional key of the vehicle and the police took the vehicle and the dead body of my husband to the PS. Police has conducted PME of the dead body of my husband at CHE Miao and thereafter handed over the body to us. We took the dead body to our village and observed the last rite. Police called me to record my statement. Accordingly, after one day, I came to the PS from my village. Police has arrested me in the present case on doubt and I am also involved in the present case. As on the date of incident when my husband was murdered, I called my accused person several times. That is, she called the accused person. I am not involved in the present case. Rather, I called the accused person asking for help to find out my husband. Police took me to office of the magistrate for recording confessional statement as provided under section 164 CRPC. I have given my deposition before magistrate. Exhibit 4 is the confessional statement deposed by me and exhibit such and such are my signature. Then comes PW 6. this is the person who has recorded the 164 statement. On 29/12/2016, I was serving as EAC cum JMFC at the office of ADC Miao. On that day, I had recorded confessional statement of accused Suman Biswas as he was forwarded on requisition by the IO for recording of his confessional statement. The accused Suman Biswas has confessed before me that he has killed late Mozang by strangulating him through the seatbelt of the vehicle, and after strangulating him, the accused has stepped thrice on the deceased by thou which was inside the vehicle. My lord, the number of step, your lordship will kindly take note, thrice. On 3/3/2017, I had recorded confessional statement of another accused, Nongkung Mozang, that is the wife of the deceased, my lord. On 29th, he records mine. On 3/3, he records the wife of the deceased. Has confessed that she had an extramarital affair with Suman Biswas, but she has denied that she had any involvement in killing. Now, if she has denied that she has not killed, how can that become a confessional statement? I don't know, my lord. Confessional statement is to self-implicating, my lord. That is a mere statement. That's not a confessional statement. The accused standing on the dock, namely Suman Biswas, is identified to be the person that he has to be identified to be the person that he has killed late Mozang. The accused standing on the dock, namely, is identified to be the person that he has killed late Mozang. I don't know, my lord, how he is identified as person who has killed, because there is nothing in the evidence that she's an eyewitness, she has seen. Whether these are typographical errors or... Exhibit 4 is the confessional statement deposed by accused Nonung, the accused standing on the dock, namely, so is identified to be the person that he has killed. Exhibit 4 is the confessional statement deposed by the accused such and such. Exhibit 5 is the confessional statement deposed by Suman Biswas. I have followed the procedure as per 164 while recording the confessional statement. The accused person, namely Suman Biswas, was produced from judicial custody. My lord will kindly take note of this line, because this judicial magistrate is making incorrect, false, misleading statement before a court of law under oath. My lord, I'm constrained to say whether this will call for an perjury or not. I'll demonstrate from the record that he's lying. He says here the accused person, and he's on oath. On oath, this judicial magistrate is saying the accused person, namely Suman Biswas, was produced from judicial custody Miao. Once I'm done with the deposition, only 2 depositions left, then I'll indicate from the record. This is the doctor, my lord, who has conducted the postmortem report. On 22/12/2016, I was posted at such and such Miao as medical officer. On that day, at about 16 hours, one dead body was brought to such and such by police for conducting PME. The examination was done on 9 hours on such and such. 23. Next day it was done. On examination, the dead body was identified as such and such male years. There was lacerated wound on the base of the left thumb, 3 cm into 1 cm into muscle deep. There are 2-step wound at left and right pubic region at the lower abdomen. 2. There were lacerated wound in left upper thigh, bruise injury in left knee. There were multiple ligature mark on the front side of the neck from 1 centimeter into 0.5 centimeter, 1 centimeter into 15 centimeter, running parallel to each other about 3 centimeter below the chin and stopping in the right side of the neck. There was darkening of skin and adjoining ligature mark on the neck. On examination, I have found that the death was caused due to ligature. However, the final reason of death can be given after doxological analysis of viscera. My lord, this should be toxological. Doxology means praising God. These are doxology is a word found in theology, not in medical jurisprudence. Medical jurisprudence would be toxology. It's typographical error. The final reason of death can be given after toxological analysis of viscera. As per requisition of IO, I have prepared postmortem report. Exhibit 6 is the PME report. Exhibit 6 are my signature. 2 is the handing over of the memo. As per examination of the own, I can say that the stepped injury was caused due to some pointed weapon. As per examination, since there was ligature mark, I can say that the strangulation was done by the rope-like material. Now the IO money. This is the last witness. On 22/12/2016, I was posted at police station Miao as sub-inspector of police. On that day, one written FIR was filed by Sri Limkom Mosang alleging that on 21/12/2016 at around 8 o'clock in the morning, his brother bought such and such, who was serving as SSA teacher, did not return back to his home. And on the next day, the car of such and such was found nearby the road at the TR camp area, and his dead body was found in the car. On receipt of the FIR, the OC has registered Miao PS and endorsed the same to me for investigation. During investigation, I have visited the PO. Photographs were taken. There were footprints on the PO, and I had also taken photographs of the footprints. Now, my lord will kindly take note of all these evidences which the IO has collected. Kindly, my lord, this has a strong bearing in this case, man. What he has collected from the place of occurrence. Photographs of the said, there were footprints on the PO, and I had also taken the photographs of the said prints. This is 1. Fingerprint experts were called for recovery of fingerprints. 2. Hair sample were found in the car and the sample were collected. 3. Inquest about the dead body was conducted and later on forwarded to CHE Miao. After PME, viscera, blood sample and hair of the deceased were collected for FSL. 4. This is the 4th evidence which they have collected. And they have collected it, he has collected it for FSL examination. The car where dead body was recovered was seized and brought to the police station. The wife of the deceased was called at the police station and her mobile handset was seized. CDR of deceased and his wife were obtained. On analysis of the CDR, it was found that the wife of the deceased was in constant touch with the accused. This she has already stated in her evidence that she was calling her. Accordingly, I apprehended the accused person, namely Suman Biswas. The accused had admitted that he had committed the alleged offense. I took the accused to PO, where he identified the footprints and stated that the said footprints belonged to him. Accordingly, I went to the resident of the accused, and on his disclosure and identification, I have seized his shoe. The accused during interrogation, the accused had also stated that while committing the crime, he had thrown the Nokia mobile handset of the deceased at the bushes nearby the PO. He has also stated that the dao used by the accused for stabbing was thrown by him after commission of the crime. As per the disclosure, I took the accused to the PO, and on his assertion, I have recovered the Nokia mobile handset of the deceased and the dao from the jungle nearby the PO. I seized the cloth of the accused, which he wore during the time of commission of the crime. My lord, even the cloth of the accused was seized, and this cloth which he has worn at the time of the commission of the offense. So all these evidences the IO has collected, my lord. My lord will see how they have conducted this investigation. Later on, the seatbelt of the car belonging to the deceased and also the seatbelt was weapon of offense for causing death of the deceased. Even the seatbelt also they have collected. After obtaining the CDR of the phone number belongs to the accused, it was found that they had some illicit relationship. The accused had admitted of having illicit relationship with the wife of the deceased. It was found that the accused was considering the deceased as hurdle in the relationship with the wife of deceased. As per the statement of the accused, in the morning of the incident, he called the wife of the deceased. He asked as to whether the deceased Mathai left his residence. He called the wife of the deceased. He asked as to whether the deceased such and such left his residence. The accused waited at empty junction and boarded into the car of deceased such and such and proceeded towards TR camp. On the way, the deceased and the accused had some argument regarding the illicit relationship of accused and with the wife of the deceased. During that time, the accused has committed murder of the deceased. So this story of murder, according to her, the deceased has told her at the police station. I had forwarded the accused Suman Biswas before magistrate for recording his confessional statement. On being confessed, the statement of the accused is recorded by magistrate as provided under 164 of the CRPC. Very conveniently, she has not mentioned the date and the time when was he forwarded. Very conveniently, she has not done. Why she has not done, I'll demonstrate, madam. On completion of the investigation, I have found that offense of 302 is well established against the accused Suman Biswas, and accordingly, I have submitted charge sheet against him. The seized materials were forwarded for FSL examination. Kindly take note. The seized material were forwarded for FSL examination, but the reports were not received by me. Exhibit 1 is FIR. Exhibit 2 is the handover of the dead body, is my signature. These are the list of the exhibits. These are the list of the exhibits, my lord. What the sketch map, PME report, disclosure statement, exhibit 8, seizure memo of car, seizure memo of fingerprints, seizure memo of black color mobile, seizure memo of accused mobile, seizure memo of Nokia mobile and Dow. Exhibit 13 is important. Exhibit 14 is the seizure memo of cloth and shoe belong to accused. Exhibit 15 is the seizure memo of seat belt. Exhibit 16 is the seizure memo of the hair and fingerprints of the accused. Exhibit 17 is the seizure memo of the photographs of place of occurrence, and exhibit 7 is my signature. Exhibit 18 is the inquest, 19 charge sheet. Material exhibit 1. So only one material exhibit. Material exhibit 1 is the CD containing photographs of place of occurrence. I do not know, my lord, how this will help the case of the prosecution. If CD recording of the place of occurrence. Cross, the accused has confessed before me and the magistrate regarding commission of the murder by him. There was no eyewitness regarding the present offense. During the time of recording 164 statement, the accused was at judicial custody. The commission statement was recorded by the magistrate as per my application. So, my lord, from the evidences, what emanates is this. The conviction was based on circumstantial evidence, more particularly two pieces of evidence. One is the confessional statement recorded under 164 CRPC, and the other is the disclosure statement which led to the discovery. I will first demonstrate to your lordship that this confessional statement is no confession in the eye of law. My lord, on the last occasion, I have said I have flag marked two page indicators, one vertically and one horizontally in the records, my lord, to show as to when he was. My lord, now your lordship will take up this written synopsis of the case which I have prepared. Since I am done with the reading of the evidences, therefore I will now indicate this. This will help us to sum up the case. This will help us to sum it up to sum it up without consuming much time. Page 3, detail of the FIR, my lord, we have seen arrest, police custody. Now, my lord, question number 4, which I have formulated. When was the appellant arrested? 24/12/2016. Arrest memo to the my lord. Arrest memo. My lord, the arrest memo which is there in the this. No, my lord, this arrest memo is regarding the wife. That arrest memo which is there in the paper book is not the arrest memo of the accused. It is the arrest memo of the wife of the deceased. The arrest memo of the accused is this, which will show that he was arrested on 24.
Before, my lord, he arguing the matter, my lord, one thing I have clarified, this paper book was not authenticated by the, my lord, registry, my lord. It was prepared by him, my lord. And this document is not available in this paper book.
No, these documents are there in the record for the convenience
So
of the court. I have done it.
kindly go kindly go to the record of the case, my lord.
Yes, absolutely.
It was not authenticated by the registry.
Absolutely, absolutely. My lord,
Because this arrest memo is not available in the paper book. That is
this, my lord, this is there in the record. He should assist the court in finding out the record. I am assisting the court. I have made this compilation out of mine. The records are before your lordship. Your lordship can always verify that this is for the convenience of the court I am giving it. So that your lordship find is convenient. If it is in a booklet form, it is convenient to the court. Otherwise, the entire records are there. The entire records are there before your lordship. The LCR has already been received. These are, my lord, why these sort of objections are, whether I have typed this.
Normally, paperwork was prepared by the registry. It was prepared by him. And that this document is not available in this paper book. That is why I am submitting before your lordship. I pointed out this point.
Okay. I don't know.
Okay, so there.
ठीक है सर लॉक अपने लॉक टाइ लॉक
No, no, I don't think it was.
ऐसे लॉक ऐसे लॉक
No, it was.
अपना तो दिसो कॉपी में
No, it was not.
एटू देखो अपनी साइड now my lord even this will help him also. He is also going through the same paper book which has been prepared. Now my lord, yes, coming back to the facts of the case, my lord. Arrest, police custody, detail, my lord. Question number 4. When was the appellant arrested? 24/12/2016. This is the arrest memo. Your lordship may verify it with the record. If anything I have written which is contrary to the record, your lordship will dismiss, impose exemplary cost. I am making this submission because I have taken a lot of pain to make all these things. And despite that, if I come to hear all these things, well, these are very disheartening. These are things I am doing to assist this court as a counsel. What is my benefit in drafting something which is not there? I have honestly said that the arrest memo which is there in the paper book, it relates to the wife of the accused, who was arrested on 26. The correct paper book I have given, my lord. Sorry, the arrest memo, I have given a copy of this arrest memo. He was arrested on 24. Yes, anyways, my lord, coming back to my arguments, when was the appeal arrest? 24/12/2016 at 8 p.m. as per the arrest memo. This is the date of his arrest. However, as per PW1, on 23/12/2016, when he went to police station, he heard that the appellant had been arrested. I have already in the evidence of PW2, your lordship has seen on 23, when he went to the police station, he has already heard he has been arrested. Be that as it may, as per arrest number 24/12/2016, when was he produced before the learned magistrate? Whether any police remand was sought? He was produced before the learned magistrate on 25/12/2016, and 4 days police remand was sought. My lord, here I beg my lord's indulgence to those 2 flap marks which I have marked in the record, my lord. In the record, because that I don't have a copy. Kindly the record to the again. 2 pink color flap marks on the last occasion I have shown, my lord. Your lordship will find 2 orders. How many days police remand was granted by the learned magistrate? As per order dated 25/12/2016, the learned magistrate sent the appellant for 4 days of police remand with a direction to produce him on 29. But those 2 flap marks, my lord, will kindly see. Because these 2 pieces of paper I don't have in my record. So I have gone through the record, I have flat mark. On 25, he was produced, 24, he was arrested, 25 produced, 25, he was sent for 4 days of police remand with a direction that he should be produced on 29. Is it there, my lord? And then on 29, he was again produced. 29, he was produced, my lord.
Yes.
Yes. On 29 order, your lordship will see. On 29, because I have noted it down the other day from the record, my lord. On 29, the order is that 29:11 a.m. he was produced. He was directed to be produced again at 4 p.m. for recording of confession on the same day. He was directed to be produced again at 4 or 4:15. Same day. So my lord, the fact remains that he was arrested on 24th. 25th, he was produced before the magistrate. He gave him 4 days of police remand with a direction to produce him on 29. On 29th, 11, he was produced. He was not sent to judicial custody. I don't think there is any reference in those 2 pieces or for any judicial. He asked the police to again produce him at 4:15. Now your lordship will come to your lordship will come to this synopsis which I have prepared, my lord. Question number 7, page number 3. So those 2 I have indicated. Since I don't have them, my lord, in my synopsis, your lordship will find that I have given some page numbers. These page numbers are basically from the paper book page numbers. Confession detail. This is page 42. Your lordship will find the confession detail. So if your lordship juxtaposes page 42 with my synopsis, that will, your lordship may kindly come to page 42 of my paper book, page 42. Yes. And your lordship will place it with the written synopsis which I have prepared. Page 42. My lord is there at page 42, my lord?
Yes.
Yes. When was the synopsis? Just to cross verify that whether what I have written in my synopsis tallies with the record or not. Question number 7, page number 3. When was the appellant produced before the learned magistrate after expiry of the remand period? What direction was passed on his production? As per order dated 29/12/2016, he was produced on 29/12/2016 at 11 a.m. He was directed to be produced again at 4 p.m. for recording of his confession on the same day. No direction to send him to judicial custody.
One minute. Here it was sent for judicial custody.
My lord, if your lordship sees my question number 8, that point will be clear, my lord.
Yes.
Yes. Question number 8, my lord, will see. Page number 4 of my synopsis. Page number 4 of my synopsis, question number 8. When was he produced before the learned magistrate again for recording his confessional statement, and who brought him to the court? On 29/12/2016 itself at 4:15 p.m., he was produced by the police, that is the investigating officer, LSI T Modi APP. I have expanded the full form. Lady Sub-Inspector T Modi, Arunachal Pradesh Police, PW8. In short, he was all along in police custody for 5 days because he was arrested on 24th for 5 days, and thereafter police produced him before the magistrate for recording the confessional statement. He was not sent to judicial custody even for 1 day, and that corroborates from page 42. Your lordship will see. The accused, namely Suman Biswas, is brought before me on 29/4/2016 by LSI, Lady Sub-Inspector T Modi, APP, at JNFC court at about 16:15, that is 4:15 p.m. to have his confessional statement recorded. I have ascertained the alleged offense punishable under 302 committed at the place of me on such and such to such and such at the time not known. Now, my lord, will come to my next question, question number 9. When was the confessional statement recorded? How much reflection time was given to the appellant before recording his confession? It was recorded on 29/12/2016 at 4:30 p.m. That is the same day. 15 minutes reflection time was given to the appellant from 4:15 to 4:30 p.m. as against 5 days of police custody starting from 24/12/2016. Now, where is the corroboration? The corroboration your lordship will find at page number 42. He says, page number 43, if your lordship comes to page 43, the last but the second paragraph, I have placed the accused, page 43. My lord is there, my lord. Page 43, last but second. I have placed the accused under the supervision of Ram Bahadur for reflection treatment from 16:15 to 16:30, 15 minutes. Which is equal to or more than the period for which he was in police custody. Goodness gracious, how a magistrate writes this, my lord. Goodness gracious. Only God can save people from this sort of, my lord, confessional statement. He writes that I have given 15, and he says, further what he says, and ascertain that the investigating agency did not have any touch with the accused during his period. The accused is again brought before me on 29/12/2015 at about 16:30 hours at place. So at 16:30 on 29/12/2016, his confessional statement was recorded. Just to show the corroboration, rest again, your lordship may come to my synopsis, the written synopsis which I have prepared, my lord. This is just to tally it with the record. I was at question number 9. Now I go to question number 10. What is the opinion of the magistrate as indicated in the confessional statement regarding reflection of time? The learned magistrate records that the reflection time is equal to or more than the period for which he was in police custody. Page 42, second last line. This is what he is recording. Whether the confessional statement was recorded in a printed format or handwritten, it was in a printed format.
One thing I have clarify, my lord. Lordship, kindly come to the page 42, second paragraph. How can he say that he was produced before from the police custody? Only thing is that Suman Biswas brought before by LT Modi. He is the investigating officer in the case. Next paragraph. I have asked detail relating to detention after arrest. He has stated that he was arrested near at about 20 hours, detained at place of detention for about 20 hours to 60 hours before being brought to the court.
Yes, yes.
Meaning there were, what meaning there were 20 hours from 20 hours to 16 hours. Before 20 hours, he was in police custody.
Yeah.
Thereafter, he was not in the police custody as per this meaning, my lord.
See the record. That is what I am submitting.
Because, my lord,
that
all the
magistrate
document is not
recording.
available in the
That
paper
is-
book. That is
yes.
why I am asking.
Yes, yes. Where is the
Yes,
this paragraph rather helps my case, because here also again he's lying. That is my next question. Here also he's the magistrate is not recording correct statement. That is precisely my next question. The Lordship will see. I have covered everything. Whether the confessional statement was recorded in printed format or handwritten, it was in. Question number 12. Just I was about to read question 12 when the public prosecutor made that submission. What is the time spent in police custody as mentioned in the confessional record? 20 hours. No date is mentioned. This goes against the record. How it can be? This is part of record. 24th arrested, 25, 4 days police remand, 29, 11 o'clock. He was asked to be produced at 4:15. Then the police brings him. It is not that he was being bought by somebody else. The police brings him. 15 minutes time, his statement got recorded. And here he is saying that it is at one place he said he was in police custody for 20 hours. Even if he was in police custody for 20 hours, even then 15 minutes time is negligible. Even if, though it is beyond the record. But here the judicial magistrate is damaging his own case, the case of the prosecution. That is why I have written in question number 12. This goes against the record. He was in 5 days, he was in police custody. From where this judicial magistrate is cooking up his own story, I do not know. Which is why I made a very serious submission when I was reading through the evidence of the judicial magistrate, where he said that he was bought from judicial custody. That is why, and if your Lordship remember, I said that I will demonstrate it from the records. It is not some submission which I am making. I am just indicating the records, my lord.
Yes.
Then, what is the time spent in police custody as mentioned in the confessional statement? 20 hours. Question number 13. In what language the rights or the safeguards of the appellant against making a confession were explained to him, and in what language did the appellant give his answer? The entire confessional statement is in English, and it is nowhere stated in what language the procedural safeguards were explained to the appellant and in what language he answered. All the requirements that are to be complied before recording of a confessional statement were in the form of question and answer, with answer either yes or no. It is hardly discernible whether the appellant knows English language or not, least to speak of the provision of CRPC as indicated in the confessional statement. Even the appellant did not put his signature in the confessional statement. He had put his thumb impression. My lord, kindly turn to page number 46. It is the confessional statement reads at section 164 procedural safeguard. This man is putting his thumb impression, page 46, right hand side, signature of the accused. It is a thumb impression. That too in a page where only the certificate appears. Coming back to my synopsis, my lord. It is hardly discernible whether the appellant knows English language or not, least to speak of provision of CRPC as indicated in the confessional statement. Even the appellant did not put his signature in the confessional statement. He had put his thumb impression. Thus, in the instant case, the compliance of the procedural requirement in recording a confessional statement was just in form and not in essence. Just formality was done, not in essence. Nowhere it is stated that, my lord, I have searched some judgments here, my lord. In this regard, my lord, that in what language this has to be recorded. Because, my lord, I was asking to myself, if my statement is recorded in Tamil language, for example, if my statement is recorded in Tamil language, my lord, I don't know Tamil, my lord. Now, whether I have said it, there is nothing in the confessional statement which says that I have explained it fine. He may record it in the language of the court. I have no argument to that proposition. What I am making, what the submission which I am making, my lord, with all humility is that there has to be something in the confessional statement that I have explained him the safeguards, that he should not make a confession, that if he refuses, he will not be sent to police custody, that if he makes it, it will go against him. He may be convicted. These safeguards, we'll have to explain. All these safeguards has a meaning. These are no formalities. We are not filling a form for appointment of any LSC examination. Yes, no, tick mark. There is nothing. This entire statement, it is all English, and your lordship will see how technically these are printed format. How technically I have explained in the requirement of 164 CRPC and 281 CRPC. What a man who puts thumb impression would know about 281 CRPC. 281 CRPC, he has not complied. 281 CRPC is that you will have to explain to this person Examination, while examining a witness, you'll have to explain to him in his own language before you take his signature. 281 CRPC. He has not complied with 281 CRPC. Exactly on this line, my lord, I could not lay my hands on any of the authorities on the language, save and except one authority, my lord. This is perhaps an area which your lordship may fill up. Since your lordship is sitting in a division bench, my lord, your lordship may fill up this area that the confessional statement, if it is made in a language which is not known to the accused person, then it has to be explained to him in his own language, the safeguards. Then only the safeguards will have some essence, some meaning. Otherwise, my lord, it will be an empty formality. The example of my confessional statement being written in a Tamil language, my lord, I will be at the mercy of the person who writes down, my lord. I do not know. For me, those would be Greek and Latins, my lord. This area, my lord, with most respect, my lord, with all humility, this area, your lordship may fill up this vacuum, my lord, that it has to be explained in the area. Then only it will have some meaning of the safeguards, my lord. Otherwise, somebody knows some language, I'll explain in some language. It will create an havoc, my lord. Now, my lord, page number 5, question number 14. Did the appellant signed in each and every page of the confessional statement? No. The confession is in 5 pages and the appellant had put his thumb impression at the last page where only the certificate appears. What was the response of the appellant with regard to the confessional statement? In his statement under 313 of the CRPC, this verbatim I have quoted, paraphrased the exact line. It is not a fact. My statement was recorded by the magistrate by threatening me, and I was severely tortured by the police for giving my confessional statement. Answer to question number 15 of the statement under 313. My lord, may kindly turn to page 36. Question number 15, answer. Page 36.
Yes.
Question number 15, answer. Verbatim I have quoted in my synopsis. It is not a fact. My statement was recorded by magistrate by threatening me, and I was severely assaulted by police for giving my confessional statement. 5 days police custody. This man is produced. 15 minutes reflection time. In jail for last 7 years. Far from his families and everything. Now, my lord, there are certain discrepancies in the confessional statement and the evidence on record. These are my question number 16 answer. What are the discrepancies in the confessional statement vis-a-vis the other evidence brought on record? Firstly, as per the confessional statement, the body of the deceased ought to have been in the seat adjacent to the driver's seat, navigator seat. As per the confessional statement, if your lordship sees, your lordship will find that it is in the navigator seat. The exact word is used as navigator seat. Whereas as per the evidence of PW1, informant, and the inquest report, it was found in the driver's seat. PW1 directly says at 2 places that from the driver's seat it was recovered, the dead body was recovered. Inquest report says off driver's seat. My lord, I have checked in the Google and in dictionary, there is no word called as off driver. It is the navigator's seat, subject to correction, my lord, or it could have been explained as the seat adjacent to the driver's seat. But to write off driver, the word off, so my lord, I will go by driver's seat because there is nothing called as off driver's seat. In the confessional statement, the correct word is used, navigator seat, one who helps in navigating, my lord. And the inquest report was found in a driver. Secondly, as per the confessional statement, the seat where the deceased body was kept was leaned behind so that others cannot notice. Whereas as per inquest report, the seat was found straight. May I indicate this from the record, my lord? These 2 discrepancies. My lord will kindly come to the confessional statement at page number 42. Page, my lord may come straight to page 44. That is the relevant part. Page 42 is from where the confessional statement starts. Page 44, the relevant part. I am reading question number 2, 1, 2, 3, 4, 5, 6, 7, 8. The third line from this. 1, 1, 2, 3, 4, 5, 6, 7, 8. The 8th line from bottom, question number 2, which starts with, then I threw away his mobile phone. Lord, may I read the relevant parameter?
Just read the whole thing.
I'll read the whole part, my lord. Question number 2 answer. This is how Nonu Mosang and I was in love with each other. Every day I used to see her. Whenever I used to go out, I could see her first before leaving. She complained that her husband was a hindrance between them. On 21/12/2016 at 8:30 hours, I was waiting for Mosang at a garage opposite to Old Baptist Church, Miao, to go to Namphai. I was told by Mosang that he had left for such and such for his duty. Then I saw the vehicle of such and such Mosang coming, and I stopped the vehicle and boarded it. We went to TR camp to meet a lady, name not known, to get some money. But Matai told that he was getting late for his duty. So we returned halfway. On the way, Matai asked me why I used to go to his quarter at Miao. I told him that his wife used to ask to help for getting household items and services, etc., which I used to bring and do it. Then he asked me whether I was having any affair with his wife. I told him that we were having affair and I cannot live without seeing her. Then Matai slapped me once in my face. Out of anger, I reacted and pulled the driver's seat belt and tied it around his neck and strangulated him till his death. Again, I moved to the back seat behind him and cut the seat belt with his dao kept in the car and tightened the belt around his neck to make sure that he is dead. Then after 30 minutes, I took the dao and stabbed him thrice in the stomach, lower part to ensure his death. Then I threw away his mobile phone, the dao broken in our rear view mirror, which Mosang had broken while trying to slap me, and the parking light reflector. Then I untied the seat belt from his neck and shifted him to the navigator seat, front seat near driver, and leaned down the seat belt so that his dead body is not easily visible. Then I parked the car on the roadside properly and left on foot towards Miao by main road. I came to that same garage from where I boarded Matai's car. I took my car, which I parked there and went to Jagun to Sri such and such house to ask for money. I had my lunch there and take back to. My lord, will see how. My lord, I was trying to conceptualize what might have happened in that car if this was to be true. This man asked for a lift. He went. He was in a garage. He saw this man was going. He was asking why and he has welcomed him inside the car, knowing that he has an affair with his wife. Then he asked him, "Do you have an affair with my wife?" He admits, "Yes, I have an affair with my wife." He slapped him. And he took out his dao, stabbed thrice, seat belt, first strangulated with seat belt, waited for 30 minutes. And after 30 minutes, he took out the dao and stabbed thrice. One slap followed by this incident. I can understand he came up with guns and to say, hello, everything has to be understood in the light of everything has to be interpreted in a pragmatic way, man. Will someone in a normal course, if X has an affair with Y's wife, just Y asks, "Do you have an affair?" "Yes, I have an affair. I cannot live without seeing her." Is it possible? And then that gentleman gives a slap and then he starts doing that act. First tie, 30 minutes waiting. After 30 minutes, took out his own dao, price, and then move it to the navigator seat and parks the vehicle in the front, parks the vehicle at a roadside. How do I know it? From the sketch map. It is not that he has pushed the vehicle in the jungle. It is a place which is in broad daylight. 8 o'clock he came. Broad daylight. Entrance to a camp which have police personnel, guards and everything. TR camp. I've even tried to find out the picture of TR camp from the internet, my lord. TR camp, this is Tibetan refugee camps. My lord will see the sketch map for a while. And then I'll make sketch map too. Where is the sketch map? Wait, the sketch, page 64. My lord will see where the car A is parked. Where car A is parked. Page 64, my lord, is there.
Yes.
A is the place of occurrence, PO. A car of such. Okay. The side of the main road, here came entrance. And he was doing all this malfeasance for more than 30 minutes without anybody's notice. Why? Because he has slapped him. And the prosecution wants the court and asked to believe this story. Coming back to my, yes, the other discrepancies. So here, my lord, he has leaned the seat behind. Your lordship has seen at page 44. He has leaned it behind so that people does not notice. Now, what the inquest report says, the position of the dead body, my lord, navigator's seat leaning behind, that is so that people cannot notice. Now, what the inquest report says, my lord, will kindly see the inquest report at page 60. I have typed it. Point number 10, but if your lordship can read the original copy, page 20, page 60, sorry, extremely sorry, page 60, point number 10, position of the body. If it is difficult, then your lordship may refer to page 62 is the typed copy, point number 10. Position of the body, lying straight in off-driver seat. Lying straight in off-driver seat, straighten, knees bent. So it is straight, straighten. Not leaning. Knees bent. Heel towards the back. This. Coming back to the second discrepancy. Secondly, as per the confessional statement, the seat where the deceased body was kept was leaned behind so that others cannot notice, whereas as per inquest report, the seat was found straight. Third, as per the confessional statement, the appellant stepped thrice in the abdomen region, whereas as per postmortem and evidence of PW7 medical officer, there were 2 stab injuries. Thus, there is no corroboration between the confessional statement and the evidence on record. So this is how, my lord, the confession was recorded. The second piece of evidence is the disclosure statement, which is at page number 47. My lord will kindly come to page 47. This is the disclosure statement. Page 47 is the disclosure. These are the 2 pieces of evidence, page 42 and page 47.
Yes.
My lord will place page 47 with my synopsis, page number 6, question number 17, disclosure statement. These are my questions. When was the disclosure statement made, recorded? Date and time is not mentioned. The space for date and time is kept blank conveniently. Page 47, your lordship will see date and time. It is blank. Everything they have filled it up, date and time. They have not. Deliberately. Neither the signature down below, I could not find any date and time. Second, who was the attesting witness in whose presence the disclosure statement was made to the IO? Whether he was examined? Sri L. Teshe, not examined. Left hand side, your lordship will see signature of witness, Sri L. Teshe. L. Teshe examined position again. I don't know. L. Teshe. Not examined, left hand side. And therefore, I have given a remark, adverse inference can be drawn under 114 illustration G of the Evidence Act. From where the alleged recovery of deceased phone and thou, alleged, question number 19, alleged weapon of murder was discovered. From where the alleged recovery of deceased phone and thou was recovered. jungle, open space. It was recovered from the open space. Here I have extracted the law laid down in Pura Kasi. He says that so far as the recovery is concerned, we cannot attach much importance to this fact as it was from an open space accessible to all. So if a recovery is made from an open space, which is accessible to all, much importance cannot be attached to that, because anybody can, it is accessible to the entire public at large. If it is from his house, his room, his cupboard, yes, some importance can be attached subject to fulfillment of other requirements. But if it is from an open place like jungle, like paddy fields, then my lord, Supreme Court says, this is exactly paraphrased, I have quoted, my lord. Supreme Court says if it is from an open space, and the reason also Supreme Court has given, that much importance cannot be attached. Number 20, whether seizure memo prepared for the alleged recovery. Question number 20, whether seizure memo prepared for the alleged recovery, who were the seizure witnesses, and whether the same has been corroborated by the seizure witnesses. My lord will kindly turn to page 55 is the seizure memo regarding the recovery of the weapon and the mobile phone leading to discovery. After leading to discovery, this happened. Page 55. My lord is there at page 55.
Yes.
My lord, description of the article seized. I'll skip 1, the Nokia phone. 2, the Singpho dao with scrapped woods, with design, length such and such, with red tape tied, such and such. My lord, who are the seizure witnesses? Left hand side, PW1 and Bukam Mosang. My lord, I take a pause here, my lord. My lord, to whatever little I understand regarding a criminal trial, if this witness PW1 who has signed the seizure witness, when he was in the dock, he should identify this, my lord, his signature. The PP should show him that, is it your signature? Yes, I have signed. I have signed. Exhibit such and such is the seizure memo, or exhibit such and such is my signature. He may not exhibit the seizure memo, but he should identify. He should say, at least when he was in the dock, he should at least say that I have signed the seizure memo. There is nothing in the evidence of PW2 which would even remotely indicate that this seizure was done in his presence. He don't say that in my presence this seizure was done. Neither he identifies his signature during the course of trial. This was never put to him, this particular document. And this is because there is one exhibit, exhibit 3, my lord, that I don't have with me. So I tried to confirm whether this is exhibit 3 or not. But this is not exhibit 3, which I can make out from the deposition of the IO. From the deposition of the IO's deposition, he has given the list of the exhibits which he have done. This is probably exhibit 13. IO is the last witness on oath, Dr. IO, yes, page number 32. Dow is exhibit 13. Dow is exhibit, it is not exhibit 3, because PW1 have only identified his signature in exhibit 3. This is exhibit 13 is the seizure memo of one Nokia mobile of this, and Dow, the PO, and 13A is my signature. And he has not stated anything regarding his presence at the time of seizure. So, seizure memo prepared. My answer to question number 20 regarding seizure memo, which was prepared in consequence of the disclosure made under section 27 of the Evidence Act. Whether seizure memo prepared, who were the seizure witness, and whether the same has been corroborated by. Yes, seizure memo prepared, page 55 on 25/12/2016. The seizure witness are Limkom Mosang, PW1, and Bukam Mosang, not examined. PW1 nowhere in his evidence has deposed that in his presence the alleged seizure was made. He had also not stated anything regarding signing the seizure memo as a witness. The seizure memo was never shown to the PW1 during trial to identify his signature. With regard to the other seizure witness, that is Bukam Mosang, it is stated that he was not examined by the prosecution, which again leads to an adverse inference under section 114G of the Evidence Act. Hence, to rely upon such perfunctory disclosure statement and subsequent seizure would tend to amount to travesty of justice, my lord. Now, number 21, whether the dhow and the mobile phone which was alleged to have been recovered at the instance of the appellant had been produced before the court and shown to the witness or the appellant at the time of trial. Answer, page number 7. No, none of the articles seized were identified by the IO or any of the witnesses or the accused. In fact, the weapon was not produced before the court. Thus, it is not known whether any such dhow or mobile as stated in the seizure memo at all exist, or it is a figment of the IO's imagination. Even the other weapon alleged to have been used for killing the deceased, that is the ligature, namely seatbelt, which was seized by seizure memo dated 25/12/2016, page number 56, was not produced before the court for identification by the IO or any other witness. My lord, in a criminal trial, my lord, when a seizure memo is exhibited as a exhibit and the materials are and the weapons are exhibited as a material witness, the weapons has to be shown to the witness. Then the witness will say in the doc that material exhibit 1 is the dhow which I have seized, white exhibit 8, that is the seizure memo. Then only we can connect the seizure memo with the object. Otherwise, it is a theory. I may write nuclear weapon in the seizure memo. I may write anything. Where is the weapon? I can understand a case where the weapon could not be discovered. But here is a case, weapon was discovered and withheld from the court. How do I know on earth that the dhow mentioned in the seizure list is the dhow which was recovered? The only way is to bring it and exhibit it as a material witness, as a material exhibit, and the person in the dock, neither it was shown to the accused, because this dhow is an incriminating material which goes against the accused. In 313, he will have to be confronted with the dhow. Then is this the dhow which you have killed? Either he say yes or he say no. Is it not denying him an opportunity to defend the evidences which are being used against him to convict him? But I can understand the police officer doing these things, but the court should also guard himself. The court could have asked him that where is the dhow? So therefore, I have said none of the articles seized. Well, in short, this is my submission. In short, page 7, the second para. In short, non-mentioning of date and time, non-examination of attesting witness is also not examined. Non-production of the article seized during trial, non-examination of one seizure witness when the other does not identify his signature in the seizure memo, coupled with the fact that seizure was made in an open space, easily accessible to the public in general, vitiates the entire disclosure statement, and as such, no credence can be attached to the disclosure statement and the consequent recovery. Now, my lord, my third limb of argument, my last and third limb of argument is, pardon me. What are the things which were seized during trial, page number 7, for FSL examination, vis-a-vis the principle of adverse presumption? My lord, Indian Evidence Act says we cannot presume against the accused in this case. The presumption is against the prosecution. My lord will see this table which I have made at page 7. It shows what are the evidence which they have collected. My lord will see particulars. Here stands from driver's seat. It was collected on 22/12/2016, page 49. Seizure witness not examined. Page 49, your lordship will find the seizure list through which they have collected the hair strands from the driver's seat, from the off driver's seat, 22/12. They are again using the word off driver's seat. I don't know the meaning of off driver's seat. 22, page 49, the seizure strand. FSL report, never sent to FSL for telling the same with the hair of the appellant. Number 3, specimen of fingerprints were also collected. Page number 50, seizure list, never sent to FSL, right hand side. fingerprints from the place of occurrence from the PO. Number 4, hair stands and fingerprints of the appellant. Even the hair stands, hair sample and fingerprints of the appellant was also collected. Page number 58 is the Caesar memo of the paper book. Never sent to FSL for tailing the same with the hair stands and fingerprints of the appellant. Blood samples, wearing apparels of deceased and organs of deceased. 23/12/2016, they have collected it. Page 51. Never sent to FSL. Nokia phone and Singpo Dao. 25/12/2016, page 55. Dao was not sent to FSL. Fingerprints on the Dao was not taken. No mention of any bloodstain in the Dao. Wearing apparels of the appellant alleged to have worn at the time of commission of the alleged offense. This was also seized. No mention of any bloodstain. The shoes were sent to FSL to, were not, my lord, I have skipped, this is typographical error. Were not sent to. Were not sent to, the word not escape. Were not sent to FSL to tally with the footprints collected from the place of the occurrence. Picture of footprints from the PO was taken, not sent to FSL. Seat belt of the driver's seat, the ligature, no mention of any bloodstain, not sent to FSL for ascertaining the fingerprints of the or the bloodstain. Now, my lord, this above table has to be appreciated in the light of two statements made by PW1 and PW8. Page number 9. PW1 says, stated, as per disclosure of the accused Suman Biswas, police has recovered the blood stain of the knife and the mobile of my brother from the jungle of discovered. Suman, the police has recovered the blood stain of the knife. So he says there is blood stain of the knife. This was a golden opportunity, according to PW1, whereas the Caesar memo says no blood stain. He says there is a blood stain. And what PW8 says, and that is where your lordship will find I have given, starts from page 14, last line, and ends at page 15, first line of the paper book. This exact verbatim in italics I have quoted. PW8 states, after PME viscera, blood sample and hair of the deceased were collected for FSL examination. And he has sent it for the FSL. The IO also says that she has sent it for the FSL. Now, my lord, now there was blood stain in the Dao and blood samples were also collected for FSL examination. Despite that, no effort was made to send the Dao to FSL and the Dao was kept hidden from the court. So the only two legal inference that can be drawn giving effect to section 114 illustration G of the Evidence Act are these. No such Dao was at all recovered, or if any Dao was recovered, it did not contain the blood stain of the deceased and therefore it was not sent to FSL. The same inference could be drawn with regard to the other evidence like seat belt, hair stain, fingerprints, footprints, etc., which were collected to connect the malfeasance with that of the appellant. My lord, will see this strange sort of, my lord, we cannot have a truncated investigation. I torture somebody 5 days, I get his confession recorded and rest I forget. My lord, will see. He collects the hair samples from the, they say that this evidence were available. I can understand a situation where this evidence were not available, but this evidence were available with the IO. He has collected the samples from the hair samples from the vehicle, from both the seats. He has collected the hair samples of the appellant also. He say he has sent it to the FSL. Why he has not produced it, the FSL report? PW1 said there was blood stain in the Dao. He received the Dao. He has collected the fingerprints of the appellant. Send it to the FSL. He doesn't submit the report. Seat belt, the ligature. He doesn't support that. He does not send it. But he has, this evidence was available. This evidence were not placed before the court, were withheld from the court. Why, my lord? That is why I said, my lord, we cannot have truncated investigation. You know, my lord, the investigation here has the potentiality of snapping the entire life of a man. None of this evidence were produced before. These were withheld from the court. My lord will kindly see, if I may take your lordship to the Indian Evidence Act, section 114. Evidence Act. These are the presumptions, my lord. Section 114.
Yes.
Illustration G. Very good.
Yes.
My lord, I'm sorry. My book, ever given it, Dada? Mm, 114, 114, 114. Yes, illustration G. That evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. So this evidence which could have been produced is not produced and is withheld. The only legal inference that can be drawn is that if you would have produced all this, it would go against him. So the prosecution knows that these are not his fingerprints. This, my lord, a person may have an illicit relationship with somebody. My lord, I'm not into the personal life of a man. But only because somebody has some personal grievance, some enmity, some political vendetta, and if that person dies, will the blame squarely fall on that person, my lord? Public figures have so many, especially political figures, my lord, have so many people who are opposing them in every forum, tooth and nail opposing, my lord. And God forbid if something happens to that public leader, will the leader of opposition go into jail? There has to be some legal, credible evidence to connect him. And there was ample opportunity. None was availed. One confession somehow, and I do not know, my lord, with all humility, my lord, with all seriousness, my lord, this judicial magistrate, his conduct is also, my lord, who has recorded, my lord, I don't wish to pass any comment, my lord, but my lord, face of the record, he is not honest. Face of the record. Somewhere he says the time is sufficient to the time which he has spent in judicial custody.
He's an executive.
He's an executive magistrate, but he says he's discharging the function of JMFCC.
Ex-assistant commissioner.
Oh,
Arunachal, my lord.
Arunachal, there was no separation of judiciary from the executive. It is only later on that.
Is why judicial magistrate.
So, my lord, I stand corrected, my lord. I'm deeply obliged, my lord. So, my lord, be that as it may, a man who is entrusted by law, the presumption is that he is entrusted. A man who is entrusted by law to it is. So, my lord, the confessional statement goes. The discovery statement, the law, my lord, I don't think, my lord, I need to labor much on citations, my lord. I'm not very fond of burdening the court with 10 citations to bring home one single point, my lord. These are, my lord, settled propositions, my lord, that the reflection time, it started with Sawan Singh, my lord. Your lordship is aware, my lord. Sawan Singh, it says 24-hour time has to be given. And if there is any allegation of torture, then equal the period. It can increase, but it cannot decrease. However, if the main purpose is to see that an environment of voluntariness is there, I have not come across a single judgment which says that 5 days of police remand can be substituted by 15 minutes of reflection time. In one judgment, 5.5 hour time, court said nothing done, not required. Not sufficient. In another case, less than 24 hours. These are all our High Court and Supreme Court. I'll give all this. In another case, one night he spent in judicial custody. Still that was not considered as sufficient time. Murder case, acquitted. In another case, division bench, Arunachal matter, Justice Nani Tagia and Justice S.K. Medhi. Half an hour reflection time, vitiates confessional statement, cannot be. This has to be at least 24 hours. My submission would be 24 hours. If it is lesser than 24 hours, then the court has to ascertain that it is made in an environment which will instill a confidence on the person that if he does not, that he is not compelled to make this confession, and if he doesn't make this confession, he will be sent to judicial custody and not to police remand. This is the end. My lord, I'll not take your lordship just because, my lord, as a convention, my lord, when you argue a criminal appeal, you will have to give some citations. Just as a convention, my lord. Otherwise, my lord, I have shown from the evidence on record, my lord. Just, this is for the convention purpose. I don't want to burden your lordship with this. I've indicated the paragraph numbers also. I'll not read the judgments as such. I've indicated the paragraph numbers. What paragraph what? Kali ratila Sanjay kota sir. Kali ratila.
Citation ke to kon likito? Citation ke to kon
Apna didi method dada. Apna geta din dada. It is Sanjay. Sanjay lagai to Sanjay kota. No. Now, my lord. My lord, one, I read somewhere an authority which says that the romance of a criminal trial is to establish an alternative hypothesis parallel to the hypothesis of guilt. And if the hypothesis parallel to the hypothesis of guilt is remotely possible, then the benefit of doubt must go to the accused, my lord. And that famous judgment, 5 judgment judgment, which says, my lord, that may be true and must be true. There is a breach between may be true and must be true, and this breach has to be covered by cogent, unimpeachable, and consistent evidence, not on presumption. Having said that, my lord, these are the judgments, my lord. If your lordship sees the index of my judgment, I start with AIR 1957, Supreme Court 637, para 10, 24-hour time was given to this. In this case, my lord, this compilation here I have paginated down on the right hand side. My lord, may kindly come to page 5. Page 5. The pagination your lordship will find down on the right hand side.
Yes.
I'm reading the second last paragraph. However, now, this is a case, Sawan Singh case, my lord, this is a full bench judgment. This is a famous case where one brother was accused of killing the other brother. And there was an approver in this case as well. And there was a confession. But because of the reflection time, my lord. However, speaking generally, I'm reading page 5, left-hand side, that's the para which starts with however. However, speaking generally, it would, we think, be reasonable to insist upon giving an accused at least 24 hours to decide whether or not he should make a confession, where there may be reason to suspect that the accused has been persuaded or coerced to make a confession. Even longer period may have to be given to him before his statement is recorded. And there are some other safeguards, page number 4, the page before, on the right hand side, which start with nevertheless. Nevertheless, usually court requires some corroboration to the confession statement before convicting an accused person on such a statement. What amounts to corroboration would be necessary in such a case would always be a question of fact to be determined in the light of the circumstance of each case. In the present case, the learned session judge has considered the question about the voluntary character of the confession made by Sawan Kumar and has found it in favor of the prosecution. What happened? Well, these are on facts, my lord. Yes, page 4, the last para, we start with the whole object of putting question to an accused person who offers to confess is to obtain an assurance of the fact that the confession is not caused by any inducement, threat, or promise having reference to the charge against the accused person as mentioned in section 24 of the Indian Evidence Act. So, my lord, I am relying on the reflection time. My lord, this entire law of confession has a basis in the Constitution. Your lordship is aware, my lord, no person can be made as a witness against himself. There's a mandate of the Constitution, but there are some leverage is given if somebody makes a confession, my lord. So therefore, my lord, the confession, conviction cannot be based solely on reiterated confession. That's a settled proposition, my lord. I need not stretch much on it. And as far as reflection time is concerned, full bench of the Supreme Court says 24 hours is reasonable. But if there is any indication of any threat, force, or otherwise, then it has to be more, but not less. Then, my lord, the next judgment which I am relying, that confession has to be compared with rest of the evidence. 1978, page number 10 of my paper book, if your lordship kindly comes.
Yes.
I am reading para 23 down below. Even so, one broad method which may be used in most cases for evaluating a confession may be indicated. The court should carefully examine the confession and compare it with the rest of the evidence in the light of surrounding circumstances and probabilities of the case. If on such examination and comparison, the confession appears to be a probable catalogue of events and naturally fits in with the rest of the evidence and surrounding circumstances, it may be taken to have been satisfied the second criteria. Then for recovery from the open place, page 20, if your lordship kindly comes to page 20. Page 20, I am reading 1, 2, 3, 4, 5, 6 lines from top. So far as the recovery is concerned, we cannot attach much importance to this fact as it was from an open place accessible to all. Then page 25, down below, the last sentence, the page 25, the court called upon to consider the evidence against the accused should still see whether there are any circumstances appearing from the record which may cast a doubt on the voluntary nature of the confession. The endeavor of the court should be to apply its mind to the question whether the accused was free from threat, duress, or inducement at the time of making the confession. Then para 18, same. Still there may be circumstance to indicate that the confession cannot be true wholly or partly, in which case it loses much of its evidentiary value. Para 19, in order to assure the truth of confession, this court in a series of decisions has evolved a rule of prudence that the court should look to corroborate from other evidence. However, there need to be corroboration in respect of each. There need not be corroboration in respect of each and every material particulars. Broadly, there should be corroboration so that the confession taken as a whole fits into the facts of the given case. As far as the discovery statement is concerned, my lord, that famous judgment, your lordship is aware, my lord, Kothaya judgment, 1947, from where the law of disclosure statement has emanated, my lord. And interestingly, my lord, that judgment was rendered in the year when India got independence. The incident was of 1945. The judgment came at 1947. It was when the Honorable Privy Council was sitting at Madras, my lord. This was a Madras case, this Kothaya famous judgment, where it says that what was actually for the section 27, for the purpose of section 27, it is that the weapon was not discovered. It is the knowledge of the person regarding the place of the weapon which is discovered. Leading to discovery, it is the knowledge which is discovered, because the weapon existed much, because the weapon, the dao, was there much before the incident had taken place. So the discovery is not of the dao. The discovery is of the knowledge of the person regarding the place of the dao. That was the law which was propounded in Kothaya case. Very interesting case, my lord. Now, from that, the law got developed, and recently, my lord, in one judgment where the Supreme Court has issued guidelines to all the high courts, is that, my lord, when a 27 statement is recorded, Ayatullah's judgment, it has to be compartmentalized, and only that part which distinctly leads to the discovery will have to be carved out from the entire statement. Because if we take the entire statement, then it will virtually lift the ban imposed by section 24 and 25. It all starts from section 24. My lord will see section 27 is one such rare section in law which starts with a proviso. Normally, proviso are there in a body of once in a section, the body of the section, and then proviso. Section 25 is one such solitary section I have come across in criminal jurisprudence, which is a proviso itself. The proviso is made a section. The section 27 starts with the word provided. Some evidence sector. Where is the evidence? Provided. Section 27. So section 27 is an exception of section 24 and section 25. Section 24 puts a ban, an embargo on confession made under threat duress. Section 25 is an example, is a species of section 24. Section 25 is when a confession is made before a police officer. Section 26 in the custody of police, and 27 lifts the ban. Lifts the ban to a limited extent, as distinctly as it leads to recovery. And it is a proviso. Section 20, that is why I said, my lord, section 27 is one such rare section in law, which is a proviso. Normally, provisos are part of a section. It will say something and then an exception in the proviso, be that as it may, my lord. Now, the latest law in 2021, it was Supreme Court issued guidelines, and with regard to section 27 disclosure statement, they said that from the disclosure statement, only that part which lead to discovery has to be extracted separately in a separate piece of paper and has to be exhibited separately. I'll give that judgment, my lord, that it has to be extracted, because otherwise court might have a tendency to read the entire statement. And if we read the entire statement and if that influence a judgment, then it will in essence leave the ban imposed by 20, it will make 24 and 25 redundant. So that's the law, which this is, in fact, this is a reference. In a reference, it is a direction passed by the three judge benches of the Supreme Court, my lord. Now, my lord, section 20, and for reflection time, my lord, apart from this, where is Gary Kota, sir? Reflection time. My lord, 1 or 2 reflection time of 5 hours and 15 minutes, and then less than 24 hours reflection time. These are the two judgments. Sanjay Kota, sir. Sanjay Kota. Bitupon Bora. Where is Bitupon Bora? Hello, I'm extremely sorry. I'm taking little time because these are the citations which I have found out yesterday night, my lord. And the junior who was there with me yesterday night, somehow he's not there in the court. Bitupon Bora. Yes, Bitupon Bora. Bitupon Bora. Bitupon Bora. तो आपकी ऑफिस को एकदम कंफ्यूज कर दीजिए। जैसे अंसारी दिस इज कॉमन हो रहा है। अच्छा, मोहम्मद यूसुफ, this is very bad. This is very bad. Yes. This judgment, my lord, I am relying on para 26, 27, 28.
Yusuf Khan.
Yusuf Khan. Yusuf Khan. 27.
This reported in?
This is reported in Manu citation. The Supreme Court citation is 2011, volume 11, page 754. My lord, para 26, circumstantial evidence.
Yes.
Undoubtedly, conviction can be based solely on circumstantial evidence. Para 26. However, the court must bear in mind while deciding the case involving the commission of serious offense based on circumstantial evidence that the prosecution case must stand or fall on its own leg and cannot derive any strength from the weakness of the deceased defense case. The circumstance from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused, and they should not be explainable on any other hypothesis except the accused is guilty. The circumstance should be of a conclusive nature and tendency. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human possibility, the act must have been done by the accused. Then section para 27, the nature of the para 27, second paragraph. The nature of admissibility of facts discovered pursuant to the statement of the accused under section 27 of the is very limited. If the accused deposes to the police officer that the fact as a result of which the weapon with which the crime is committed is discovered, and a result of such recovery of the weapon is made, no inference can be drawn against the accused if there is no evidence connecting the weapon with the crime alleged to have been committed. The weapon has to be connected with that of the accused, and the connection could have been done through the FSL report. An inference cannot be drawn that he has done it. Even if, for the sake of argument, if we say that that statement under section 27 in this case was actually made by him, even if presuming it, even then, if something is recovered, unless and until we link it, it cannot go against him. Then, my lord, the next judgment which I am referring is Bitupon Bora. Yes, Bitupon Bora, Bitupon Bora. Itu duta de. Bitupon Bora. Mana beya lagi sih namu. Bitupon Bora. Now this Bitupon Bora. Yes, para 7 and para 9, and this all judgments has attained finality. None of these judgments were appealed or overturned. My lord will kindly come here. Less than 24 hours of reflection time. Para 7 and para 9. I'm skipping the factual. I'm only relying on the law. His evidence, para 7, that is the last page, 1, 2, 3, 4, 4 lines from top. His evidence shows that the appellant was produced before him on the previous day at 4 p.m. and after cautioning him about the legal consequence of making a confessional statement, remanded in judicial custody for reflection with a direction to reproduce him on the following day, that is on 2/8/2007, and accordingly the appellant was produced at 11 a.m. by the court constable. Thereafter, the learned magistrate again cautioned him as before and allowed him 3 hours time for reflection. Much better case than us. Still then the court say at para 9. By the impugned judgment, the order the learned trial court accepted the aforesaid confessional statement. It is noticed from the evidence of PW7 that the provision of 164 CRPC were complied with in form, but not in essence, inasmuch as no inquiry was made from the appellant regarding the treatment he is being receiving in custody in order to ensure that he was not subjected to any extraneous influence or police influence. And further, he aged about 20 years were apparently not given sufficient time, not even 24 hours for reflection to satisfy that he really wanted to make the confession voluntarily to meet the necessary compliance of 164 and 281 CRPC beyond doubt. This was a much better case than us, but even then our High Court have said that since it is less than 24 hours, we cannot accept this. Then a division, I rely on two division bench judgments. One is by Justice Sridhar Rao. Reflection time, yes. Sridhar Rao. This is the division bench judgment. 5 hours, 15 minutes reflection time. In this case, 5 hours and 15 minutes of reflection time was given. First, I will show where 5 hours, 15 minutes. My lord may come to para 37 of this judgment. Your lordship will see.
1 minute.
Para 37, your lordship. Para 37 will show that that the reflection time was 5 hours, 15 minutes, and then the law I will show in the other paragraph. Para 37 will show he was produced at 10:45 and it was recorded at 4 p.m. From 10:45 to 4 p.m. reflection time was given. Para 37. That is 5 hours, 15 minutes. Para 37. My lord is there?
Yes.
My lord will see. Para 37. Now let us see. Let us see how far the above directions are followed in the case under consideration. A careful perusal of the evidence on record as well as the other orders passed by the magistrate reveals that the accused was taken into police custody on 16/4/2020. 2002. He was produced from before the magistrate only on 24/2020 2002 at about 10:45 a.m. On his production before the magistrate, the learned magistrate gave necessary instruction warning at about 10:45 and thereafter recorded at 4 p.m. So from 10:45 to 4 p.m. is 5 hours, 15 minutes. And what the division bench of this honorable court has to say, your lordship will kindly come to page number, internal page number 5, para 29. So situated, let us see how far the confession in question makes out the charge brought against the accused person. Before we proceed further, we find it necessary to know how much time needs to be given to a confessing accused person to ponder over the statutory warning given to him by the magistrate and to decide whether he is going to make a confession, since a confession cannot be acted upon unless there is a clear finding that the confession made by the accused is voluntarily and truthful. It is true that there is no hard and fast rule as to the time that needs to be given to a confession, to a confessing accused person to think over the warnings rendered to him by the magistrate and to decide if he is still desirous of making a confession. In that connection, we may look into the decision rendered by Honorable Supreme Court in the case of Sawan Singh. I have already shown that decision. In Sawan Singh, Ratan Singh, Supreme Court clearly held that a confessing accused generally needs to be given 24 hours time to have proper reflection on the warning given to him so that such an accused person does not make any confession under any kind of influence whatever. Proper reflection time has to be given. The whole object of questioning to an accused person who offers to confess is to obtain an assurance of the fact that the confession is not caused by any inducement, threat or promise having reference to the charge against the accused person as mentioned in section 24 of the Indian Evidence Act. There can be no doubt when an accused person is produced before the magistrate by the investigating officer, it is utmost importance that the mind of the accused person should be completely free from any possible influence of the police, and the effective way of securing such freedom from fear to the accused person is to send him in jail custody and give him adequate time to consider whether he should make a confession at all. It would naturally be difficult to lay down any hard and fast rule as to the time which would be allowed to an accused person in any given case. However, speaking generally, it would, we think, be reasonable to insist upon giving an accused person at least 24 hours time to decide whether or not he should make a confession. Where there may be reason to suspect that the accused has been persuaded of cohort or to make confession, even longer period may have to be given. to him before his statement is recorded. In our opinion, in the circumstance of this case, it is impossible to accept the view that enough time was given to the accused to think over the matter. Enough time is 5 hours, 15 minutes. The decision rendered in Sawan Singh case has been again reiterated in the case of Chinna Gowda versus State of Mysore, 63. It has been pointed out by this court in Sawan Singh that when an accused person is produced by the investigating officer before the magistrate for recording his confession, it is of utmost importance that his mind should be completely free from any possible influence of the police, and he must be sent to jail custody and given adequate time to consider where he should make a confession. My lord, the decision rendered. Now, the same page, I'm reading the last 1, 2, 3, 4. It is a settled law, the fourth line from bottom. It is a settled law that at reflection, but no hard and fast rule could be laid down as to the it is a settled law that at least 24 hours should be given to the accused to decide whether or not he should make a confession. Now, there is another very celebrated judgment regarding 164 CRPC, and that judgment has been reproduced in this judgment, and therefore I am not coming up with that judgment separately. Para 36, page number 7, internal page number 7, para 36. This is Ravindra Kumar Pal's judgment.
Of the same judgment.
Of the same judgment. I am reading para 36. Para 36 lays down. Para 36, in para 36, the division bench of this court has reproduced the principle laid down in Ravindra Kumar Pal case, and Ravindra Kumar Pal case has laid down as many as 11 principles regarding 164 CRPC. This Ravindra Pal case is the most frequently case referred to at present time with regard to the principle of 164. The principles are here. My lord, is there at page 30, para 36? Yes. We may note here that in Ravindra Kumar Pal, Honorable Supreme Court held that the requirement of 164 CRPC are to be followed strictly. The relevant part is reproduced below. Para 64 of that judgment. The following principle emerges with regard to 164. These are the provisions. The provision of 164 CRPC must be complied with not only in form, but in essence. Just this yes, no, in form, it has to be in essence. Before proceeding to record the confession statement, a searching inquiry must be made from the accused as to the custody from which he was produced and the treatment he had been receiving in such custody in order to ensure that there is no scope for doubt of any sort of extraneous influence proceeding from source interested in the prosecution. 3. A magistrate should ask the accused as to why he wants to make a statement which surely shall go against his interest in the trial. The maker should be granted sufficient time for reflection. He should be assured of protection from any sort of apprehended torture or pressure from the police in case he declines to make a confession statement. A judicial confession not given voluntarily is unreliable, more so when such a confession is retracted. And here this has been retracted under 313. The conviction cannot be based on such retracted judicial confession. Non-compliance with 164 CRPC goes to the root of the magistrate jurisdiction to record the confession and renders the confession unworthy of credence. During the time of reflection, the accused should be completely out of police influence. The judicial officer who is entrusted with the duty of recording confession must apply his judicial mind to ascertain and satisfy his conscience that the statement of the accused is not on account of any extraneous influence on him. At the time of recording of the statement of the accused, no police or police official shall be present in the open court. Confession of a co-accused is a weak type of evidence. Usually the court requires some corroboration from the confessional statement before convicting the accused person on such a statement. These are the principles, my lord. Reflection time question. This is then one Guddu Tante. This is also a division bench order, a division bench judgment, my lord. This is by Justice S.K. Medi and Justice Nani Tagia, Arunachal bench. Here, 30 minutes reflection time in this case. Court says 30 minutes cannot be. My lord, I'll just keep the other parts. I'll take your lordship to internal page number 3, paragraph 10.
1 minute. Yes.
My lord will kindly come to internal page number 3, para 10. The last sentence of para 10, second last sentence, which starts with the word as regard on the right hand side. Just 1 to 3 lines from from bottom, para 10. As regards reflection time before making such confession, my lord is there. As regard reflection time before making such confession, it was deposed that no less than half an hour was given for such reflection. More than half an hour was given, no less than half an hour. That was the reflection time. What this court has to say? This court's finding on reflection time is at internal page number 4, which starts from the second line. Let us first examine the evidentiary value of confession. Let us first examine the evidentiary value of confession so far as the instant case is concerned. The confession report does not indicate that prior to the same, the accused was given required time and environment to bring in voluntariness in his confession. It is also not stated under whose company or supervision the accused was kept during the time of reflection. On the other hand, it is on record that no separate judicial custody was available in that building, and the accused was straightaway brought for the confession from the building, which was a police custody. The learned magistrate himself has said that not less than half an hour time was given for reflection. This, in the opinion of the court, is not adequate or reasonable time. Though no straitjacket formula can be applied as to what would be a reasonable time, various judicial pronouncements have laid down that at least 3 hours is considered to be reasonable time. We are further of the opinion that no environment was made which can be termed as free and uninfluenced by any coercion, in as much as the accused was brought straight from the police custody in that view of the matter. 3 hours, my lord, in cases where the man is brought from judicial custody, 3 hours times are given normally if he are brought from judicial custody. From police custody, more so when he was tortured for 5 days. In this type of cases, at least 2 days reflection time ought to have been given, and he should have been apprised of his right of not making a confession, especially the right that if you do not make a confession, you will not go to police custody. All these rights would have been apprised to him 2 days beforehand, then send him to judicial custody. Then when he comes back, again apprise him, then send him for 2 or 3 hours somewhere else in the custody of some court personnel, then record the confession. Probably that will inspire the confidence. Last, this is by Justice Ansari, Kamal Hazarika versus State of Assam, 2013. Here, probably 7 hours. It was also discarded. That 7 hours is too less a time. My lord, I'm relying on page para 43. Para 43 is nothing but a reproduction of Ravindra Kumar Pal case, that principles which I have just now read. So I'll not repeat it. Para 43, I'm relying. In the present case, the accused, para 44, I'm relying. In the present case, para 44, I'm reading, in fact. In the present case, the accused was admittedly in police custody for 72 hours. And though it had been directed that he must be medically examined after every 24 hours, the accused appellant was not so examined, in as much as he was examined only once. Thus, no medical examination was done in terms of that. Nothing of this sort was even remotely followed in our case. No medical examination. Nothing is there in record. There is also unshaken evidence, which we have already pointed out, that both the hands of the accused appellant were tied upward and he was beaten up. The 7 hours reflection time, your lordship will find somewhere this. There is a 7 hours reflection time. I have read it. Ought to have given sufficient reflection time for reflection. Is close to a magistrate. This is he was 72 hours in police custody and he was given a reflection time of 7 hours. Now that 7 hour, your lordship, that in our considered view, the accused appellant ought to have been kept in judicial custody for longer period. Sufficient time for reflection to reassure him. Even if he choose to make such confession, no harm could, because a magistrate must use 7 hours. Where is that? Well, I'm extremely sorry, I'm consuming your lordship's valuable time. But this case, I'll refer to that particular line here. Yes, page 30, para 34, bearing in mind what has been pointed out, we now return to the evidence of SDJ, para 34, who had recorded the judicial confession. We find from his evidence that the accused appellant was produced before him at 1:10 p.m. and having given the accused 3 hours time, sorry, not 7 hours, 3 hours time for reflection. 3 hours time was, sorry, not 7 hours, 3 hours time. So 3 hours time was not found to be adequate, especially when he was in para 34, especially when he spent 72 hours in police custody. And here he has spent 5 into 24 would be. Even who? 120 hours probably in this case, 5 days. So that's my case, my lord. This part which I've the judgment, the time which I've this is only for convention, my lord, is a part of convention. Otherwise, my lord, here this confession and this. Yep. My lord, the thing which is disturbing in this case is not only the conduct of the executive magistrate, but my lord, the IO, why on earth he has not, despite collecting all these samples and evidences, making Caesar list, sending it to FSL, why he has withheld all this from the court, my lord, I don't know. Even the weapon he has withheld, that should not have been. I'm deeply obliged, my lord. I'm subject to what?
May I please your lordship? I shall submit my case on tomorrow. Today I clarify some point, my lord, which has been argued by my learned friend, my lord, in this case. First, your lordship kindly come to the 164 statement.
No, you can start tomorrow then if you want to have it tomorrow.
I want to clarify one thing. He has said that the accused person has not put his thumb impression or signature each and every page that is available in the instant case. Each and every page is, my lord. I have gone through it, my lord. Thumb impression is available. If your lordship see minutely, everything is available. And another point is important, my lord, that he has said that he was arrested on 24/12/2000 to 2014, no? 2014. 16. If your lordship count 5 days, 24, 25, 26, 27, 28. 20 days his police custody has been completed. That all this document is not available with me, my lord, because it is on the part of the record. Tomorrow, before I argued the case before the honorable, I may be allowed to go through the, my lord, record, my lord, to see all these things, whether 20, what happened.
That way you'll be consuming more time. So instead of having it tomorrow, we can have it day after tomorrow, and
Yes,
then
sir.
meantime you can study your case.
Yes, my lord. Because verifying the record is very much necessary, my lord.
But this was Leonard counsel for the appellant. Also heard Mr. NN Bichaudhry, the public prosecutor, Arunachal Pradesh. 13 part is for the hearing, as you know.
At 2, my lord.
You are leaving on
At 2, my lord.
Why 2?
Because in morning, day after tomorrow, I shall go through the record. I shall go verify the record. my lord.
Why not you go through the records now?
Today, my lord, I have some. Yes, my lord. In the morning,
Or
I
you
shall.
can go through it tomorrow also with the permission of the registry.
Yes, ma'am. That will be available here, my lord, record.
Records I have.
Earlier, it was double XL. No? Okay, my lord, now I can verify. Yes, ma'am.
Wow.